Hello and welcome to these opening remarks for this rather remarkable case. To the best of my knowledge, this is the first case where a sitting Australian Federal Court magistrate is being put on trial in a People's Court in Australia. Those of you who don't know me, my calling is Peter Andrew of the Nolan family. I'm also known as Joshua Brandon Baum. I have spent some 5 years getting to this point with this case. You're welcome to go and read my other videos or watch my other videos and read my books. What is most important about this case is that this is the first time that we are bringing a magistrate to trial, public trial, for the crime of stealing property from a man via the family law courts. David Dunkley clearly is a criminal. He clearly had no right to do what he did. He's never provided any evidence that he had any claim of any right to do what he did, and he simply stole the proceeds of my house. Now, many hundreds of thousands of other Australian men have suffered a similar fate. Many people have said, well, I should just shut up and put up with it, and I should just get on with my life because stealing my house and kidnapping my children is just something that men should tolerate, right? And many men have said that to me in Australia. Many men have said that to me in Australia. But the fact remains that in Australia, large numbers of men kill themselves every year when they find out just how much they are hated on by their fellow Australian men, not to mention the women. When men find out that they are considered fourth-class citizens behind women, children and dogs, many of them take this realization very hard. This is why you are seeing so many Australian men kill themselves, especially in divorce. I mean, the fact is that in Australia, a man is about 8 more times to kill himself in divorce than a woman who has actually been raped is likely to kill herself. So people often say of rape victims, they attempt suicide very often. No, they don't. They just attempt a little bit of self-harm in an attempt to gain some attention and some sympathy. Whereas men, when they attempt to kill themselves, generally succeed because they're not attempting suicide to gain attention, because that won't get them any attention anyway. They attempt suicide with the intent of killing themselves. Those children that these men leave behind then grow up fatherless. And I've met women who've had their fathers commit suicide. Okay? I've met them and I've looked them in the eye. And this idea that when a father commits suicide, it doesn't have any effect on the daughters of the fathers is complete rubbish, which I rebut most strenuously. Of course, a father committing suicide also has a great effect on the sons of the father, not just the daughters. But nobody cares about the sons of fathers, and nobody cares about fathers themselves in Australia. Indeed, not even other fathers care about fathers in Australia. Fathers are just supposed to suck it up. They're just supposed to be drones, willingly sacrificing their life for the benefit of others, and if he complains, by the living Harry, he should be given some stick if he so much as complains. And that's what happens in Australia. There's not a single person in the country who's going to deny that when a man is incredibly criminally victimised in Australia through the family law courts, everyone tells him just to shut up and get on with it. Nobody's going to deny that. Even my own father said to me, if you complain about what's happening to you in your divorce, you won't have any friends. I've seen it happen before. So my own father, as a man of near 70 years of age at the time, knew full well that when men, quote, complain about being criminally victimised in these courts, other men cause him trouble. Other men are, quote, no longer his friend, unquote. People know this to be true. It was going to take a man of some courage and some convictions to stand up against these criminals in these family courts, and not only to stand up against the criminals in the family courts, but to stand up against the culture in Australia which pervasively hates men. Pervasively hates men. Any man who so much as complains that his children are kidnapped will be persecuted and hated on in Australia. I've spoken to many such men. It was going to take a man of some significant character to be able to stand up and be hated and persecuted for years on end to gain his path to justice. And that's exactly how I've been treated. I've been hated on and persecuted, not only by women, not only by my enemies. I've been hated and persecuted by my very family. Now, you people listening to this might want to listen closely to that. I have been hated on and persecuted by my very family. My wife, my children, my father, my brothers, and my cousins have all hated on me and persecuted me. How about that? And this is one thing that men find devastating when they go through the divorce process, that the most disgusting, badly behaved, criminal, vindictive bitch of a wife will be supported over and above the best of honest men of honour and integrity. Men find that very difficult to believe. They really do. So in this lead case of me versus David Dunkley, not only did I have to put up with the theft of my house and the hatred of many people who did not even know me, I had to put up with the persecution and hatred of those who would have claimed to love me. And as a result, I left. I left Australia because any nation, any land, any country that persecutes me the way that I was persecuted, while engaging in idolatry, female idolatry, and the support of the most disgusting, criminal, vindictive behaviour that my wife engaged in, I don't want to live in that country. I moved to somewhere where I'm respected, and that land is called Germany. Germans know what Nazis look like, and they don't want them back. Apparently, Australians don't know what Nazis look like. Okay? So you men on this jury and you people in the public domain who listen to this, you just remember, you are driving men to suicide with your pervasive hatred, your attitude of male disposability, and your pervasive female idolatry in Australia. And you want to understand that's killing men and leaving children fatherless. And it's taken a man like me to stand up and say, no, we are not going to tolerate this anymore. And this case, this groundbreaking, precedent-setting case against David Dunkley is going to show the people of Australia just how disgustingly men are treated. And we demand to be treated as equal before the law, and we are not going to tolerate anymore this rubbish that has been thrown at us, and we're not going to tolerate being fourth-class citizens behind women, children and dogs. Now, you, the public of Australia, and you, the 12 men on the jury, you are about to hear evidence that is devastating. Just devastating. And you are about to judge this evidence for yourself. Those of you who take the time to judge this evidence, as the jury will find what I'm saying is true. And the truth is not very pleasant. So thank you for listening to these opening statements. I hope you find them enlightening and informative. You're now about to listen to a series of evidence that has never been created and presented to the public before. Thank you very much for listening. Hello and welcome. I am now going to read into evidence the Affidavit of Accusation against David Dunkley, written today, 2013, 0422, the 22nd of April, 2013. As with all these affidavits, I will read it in word for word, and so that you can listen to it as well as read along with it on the screen, or you can read it separately. But this is being read into the public record and into evidence for the jury trial of David Dunkley. So, from the free man commonly called Peter Andrew of the Nolan family, standing in God's kingdom, in care of Instant Business Intelligence, 17 CA Rossetti, 2nd District, Bucharest, Romania. Fax number and email supplied. 2. Lawful notice to respondent, the human being calling himself David Dunkley, also acting as Australian Federal Magistrate David Dunkley, Garfield Barwick, Commonwealth Law Courts Building, 13 George Street, Parramatta, New South Wales 2150, GPO Box 9991, Parramatta 2123, Australia. 22nd of April 2013. You can see I've signed each page original document. For those who don't know what's going on, some explanatory notes. To the public who may be reading this affidavit of accusation and not know what is happening. The so-called courts of law in Australia are a criminal cartel meant to make slaves of the Australian people. This has been well proven, and the evidence is presented on the Crimes Against Fathers Australia website for anyone who would like to determine the veracity of that statement for themselves. In the face of the criminality of the courts and the government, I, Peter Andrew of the Nolan family, and my colleagues have made efforts over the last 5 years to introduce new and proper courts of law into Australia, so as to reintroduce the rule of law in Australia. My colleagues and I have received little support from the common Australian people, who seem to prefer to remain ignorant of the situation in which they find themselves, rather than to educate themselves on this matter. By such willful ignorance, most Australians have waived any right to have any say in how those of us who have been risking our lives propose to reintroduce the rule of law onto the land known as Australia. If you wanted a say, you were well advised to speak sooner. In April 2011, new courts were proclaimed into existence with 29 signatures on the proclamation. The prerequisite needed was 25. These courts were nominally called the People's Courts of Australia. It was expected that soon after a Secretary of the People's Courts of Australia in Sydney would be found and we could begin running our first cases. As matters transpired, no man came forward to fill this position for Secretary for fear of persecution by the criminals and the government. Eventually a man came forward to fill this position in Melbourne. Since I was being slandered by one Chris Merritt, who lives in Victoria, I decided to run the first case of the People's Court of Australia in Melbourne, and for Chris Merritt's very simple slander case to be the test case. It is an open and shut case. Chris Merritt does not deny slandering me. However, ASIO, who I will remind you are your servants, whom you pay with your tax dollars, making you their master responsible for their actions, decided to pay a visit to our first secretary and harass him and intimidate him. Since so little support was forthcoming from the Australian public for this man, he has well-founded fears for his freedom. Other men have been jailed, Ian Henke, for example. Based on this harassment and intimidation, I am now launching the Men's Business Association Law Services, which offers the MBA Law Courts as a service. The MBA Law Services is a global service that operates in natural law and common law jurisdictions. If you want to know more, there is a lengthy video on this link, and the link is provided there. The YouTube channel is called MBA Law Services. As the founder of the Men's Business Association, I claim the right to allow MBA law courts to operate in such a way that the jury members and secretary can remain anonymous to the public so long as all evidence is presented to the public for review. In this way, the veracity of the jury trial process can be maintained in the face of the clear criminality of the Australian federal government, particularly the secret police thugs who go by the general name of ASIO. You, as a member of the public, are invited to observe this process so that you too are sure that the due process of law was followed and that David Dunkley was given a fair trial. The purpose of this process is to ensure the due process of law is followed and that David Dunkley gets a fair trial. The only way to do that is to do it in the open view of the public and not to risk the lives of those who are brave enough to be jury members or secretaries of the courts. Lawful notice to respondent. The human being calling himself David Dunkley, also acting as Australian Federal Magistrate David Dunkley. Garfield Barwick Commonwealth Law Courts Building, 1-3 George Street, Parramatta, New South Wales 2150, GPA Box 9991, Parramatta 2123, Australia, fax number supplied, 22nd of April 2013. Let right be done, though the heavens should fall. Notice to principal is notice to agent. Notice to agent is notice to principal. I, commonly addressed by the calling of Peter Andrew of the Nolan family, or Joshua Brandon of the Bohm family, hereinafter referred to as the principal, in my correct public capacity as beneficiary of the original jurisdiction, being of majority in age, competent to testify, a self-realized and free sentient man, my yes be yes, my no be no, do state that the truths and facts herein are of first-hand personal knowledge, true, correct, complete, not just true and correct, certain and not misleading, so help me God. This notice is addressed to the human being calling himself David Dunkley, also acting as Australian Federal Magistrate David Dunkley, herein also referred to as the respondent. Affidavit with respect to the crime of theft committed against the man known as Peter Andrew of the Nolan family. Item 1. Principal is of legal age and competent to testify. Item 2. Principal has first-hand knowledge of the facts stated herein. Item 3. Principal makes oath that in approximately late 2009 I was informed of a proposed meeting between the woman calling herself Jennifer Marguerite Toll and the woman calling herself Louise Henderson. These women were making some form of claim over my property. Item 4. Principal makes oath that all reasonable efforts were made to communicate with these two women. All such efforts were rebutted and no reasonable communication took place due to the unprofessional and willful nature of these two women. The correspondence sent is in the file attachment named as follows: 01 PN Notice to Louise Henderson Package All. Much of this documentation was also directed towards David Dunkley, because I had a letter from a woman calling herself Amanda Morris claiming that it was going to be David Dunkley who would meet me on November the 26th and not Louise Henderson. So I sent this documentation to both of these parties. What I will do now is read into evidence, read into the public record and read into evidence for this trial all the documentation that was sent to Louise Henderson and David Dunkley prior to me arriving in Australia on about the 21st of November 2009. This video stream will now transition to the reading of this documentation into the public record and into evidence for this trial. I am now going to read into the public record and into evidence for this jury trial the package of notices to Louise Henderson, which was sent before the 24th of November 2009. What this package will demonstrate is that I made all efforts to correspond with David Dunkley and Louise Henderson prior to this court meeting. It will also show that I had sole claim to the proceeds of my labour for the 25 years prior to the court meeting. Okay, so this will be read in, as per usual, word for word. Facts 2. The human being calling herself Louise Henderson, also acting as Federal Magistrate Louise Henderson, and the human being calling himself David Dunkley, also acting as Federal Magistrate David Dunkley. The human being calling herself Amanda Morris, also acting as Associate to Federal Magistrate Louise Henderson, Garfield Barwick Commonwealth Law Courts Building, 1-3 George Street, Parramatta, New South Wales 21550, GPA Box 9991, Parramatta 2123, Australia. Fax number supplied. Date 15th to the 11th 2009. Subject Service of Claim of Right. To all the human beings who call themselves Amanda Morris, Louise Henderson, David Dunkley, salutations. Please find attached my notice of understanding and intent and claim of right. This is a copy of the original signed version that was sent to Queen Elizabeth II, Michael Jeffrey, Kevin Rudd and Robert McClellan. I have also included the default judgment for the non-response and created the permanent estoppel by acquiescence. In short, these four people have agreed I have these rights and they cannot be revoked. If you wish to continue to attempt to steal my property without my consent, I suggest you familiarise yourself with my rights. And I've signed it, and it's one page. So this is to say that I sent my notice of understanding, intent and claim of right to these three people. So this is a lawful notice I sent to respondent, the human being calling herself Louise Henderson, also acting as Federal Magistrate Louise Henderson, Garfield Barwick Commonwealth Law Courts Building, 1-3 George Street, Parramatta, New South Wales 2150, GPA Box 9991, Parramatta 2123, Australia. It was sent on the date of the 23rd of the 9th, 09, so this is 2 months before this court meeting. And it's an affidavit with respect to the proceeds of the sale of my house. It's 8 pages long. Notice to respondent. The human being calling herself Louise Henderson, also acting as a Federal Magistrate Louise Henderson, Garfield Barwick Commonwealth Law Courts Building, 1-3 George Street, Parramatta, New South Wales 2150, GPA Box 9991, Parramatta 2123. Let right be done though the heavens should fall. Notice to principal is notice to agent. Notice to agent is notice to principal. I, commonly addressed by the calling of Peter Andrew of the Nolan family, hereinafter the principal, in my correct public capacity as beneficiary to the original jurisdiction, being of majority in age, competent to testify, a self-realised and free sentient man, my yes be yes, my no be no, do state that the truths and facts herein are of first-hand personal knowledge, true, correct, complete, not just true and correct, and certain, not misleading, so help me God. So this is under oath. This notice is addressed to the human being calling himself Louise Henderson, also acting as a Federal Magistrate Louise Henderson, hereinafter known as the respondent. Affidavit with respect to the unlawful theft and sale of 8 Schofield Parade Pennant Hills between Jennifer Marguerite Nolan and Peter Andrew Nolan. 1. Principal is of legal age and competent to testify. 2. Principal has first-hand knowledge of the facts stated herein. 3. Principal makes oath that he has received an order dated 16th of June 2008 issued by the human being calling him or herself Judicial Registrar Johnson of the Family Law Court of the Family Court dispute brought by Jennifer Marguerite Nolan with respect to the sale of the house located at 8 Schofield Parade, Pennant Hills 2120, and there was a copy supplied. Principal makes oath that he is aware of an invitation issued by the private run-for-profit company calling itself the Australian Federal Magistrates Court, inviting the corporate fiction by the name of Peter Andrew Nolan to some time in the month of November 2009. For sometime in the month of November 2009. Principal makes oath that he is not in possession of details of this invitation and wishes to engage in proper written communication with the human being who is the authorised agent for the run-for-profit company calling itself the Australian Federal Magistrates Court, so as to peacefully and effectively conclude business proceedings. 6. Principal makes oath that he believes the respondent is the appropriate human being with which to correspond in order to peacefully and effectively conclude business proceedings. 7. Principal makes oath that the sale of the property known as 8 Schofield Parade, Pennant Hills, New South Wales 2120 was performed against his written instruction and that this not be done and therefore said sale progressed without the consent of Peter Andrew Nolan. 8. Principal makes oath that at the time of this sale, solicitors for Principal Watts McRae had at no time provided written documentation nor made verbal comment to the effect that engaging a solicitor declared Principal a ward of the state. 9. Principal makes oath that at no time did the solicitors for Principal Watts McRae provide written documentation nor made verbal comment to the effect that the loyalty of Watts McRae and engaged solicitors was to the Law Society of Australia and the Family Court by oath, and that they were acting in the best interests of the Law Society of Australia and were not acting in the best interests of Principal. 10. Principal makes oath that at the time of this sale, solicitors for Principal Watts McRae had at no time provided written documentation nor made verbal comment to the effect that they may, at their discretion, without informing Principal, engage in side conversations with the members of the Australian Law Society to create circumstances beneficial to the Australian Law Society, which would also precipitate circumstances detrimental to Principal. Principal makes oath that at no time of this Principal makes oath that at the time of this sale, solicitors for Principal Watts McRae had at no time provided written documentation nor made verbal comment to the effect that they had a clear conflict of interest in that as members of the Australian Law Society and under oath to serve the best interests of that society, their loyalty to the Australian Law Society conflicted with the interests of Principal. 12. Principal makes oath that at the time of this sale, solicitors for Principal Watts McRae had at no time provided written documentation nor made verbal comment to the effect that the Australian Federal Magistrates Court had a clear conflict of interest in that as a member of the Australian Law Society, that the Australian Federal Magistrate had a clear conflict of interest in that as a member of the Law Society and under oath to serve the best interests of that society, the Australian Federal Magistrate's loyalty to the Australian Law Society presented a clear undisclosed conflict of interest in any ability to judge impartially in the best interest of Principal and Jennifer Marguerite Nolan. 13. Principal makes oath that on the day of March 7, 2008, Principal met with the representatives of Watts McRae. Principal makes oath that he had serious concerns as to the poor performance of Watts McRae in his estimation, specifically with respect to refusal to pass along requested communications, and specifically challenged the effectiveness of representation. 14. Principal makes oath that representatives of Watts McRae made many verbal comments to the effect that they were working to represent Principal's interests, quote, effectively, unquote. Principal makes oath that a Watts McRae representative, Jacqueline Vincent, used words to the effect of, quote, do you have confidence in our firm to represent you in the most effectively to the court, unquote. In asking Principal specifically if he had confidence that Watts McRae would effectively represent Principal's best interests. Principal makes oath that he was under the impression that every effort was being made by Watts McRae representatives to assure him his best interests were being represented. 17. Principal makes oath that he felt at that meeting there was, quote, something wrong, unquote, and that some deception was being perpetrated upon him. However, he could not comprehend what that deception might be. 18. Principal makes oath that at the time he was well aware that under commercial law any contract or any performance of duties that are performed in deception or as a result of deception are null and void and can be redressed via legal processes at a later date. Therefore, Principal determined that the course of action to pursue was to allow the deception to stand, to continue with the engagement of Watts McRae and deal with the deception at hand at a later point in time. 19. Principal makes oath that representatives of Watts McRae made many verbal comments to the effect that the Australian Family Court and proceedings herein were, quote, fair and reasonable, unquote, and that I could have every confidence in a, quote, fair and reasonable, unquote, outcome would be achieved. 20. Principal makes oath that Watts McRae at no time provided written documentation nor made verbal comment to the effect that the lawyers for Jennifer Marguerite Nolan and the registrars and magistrates were part of a collusive society that worked towards its own best interests in preference to the interests of their clients. 21. Principal makes oath that Watts McRae at no time provided written documentation nor made verbal comment to the effect that the Commonwealth of Australia is a sovereign entity registered on the United States Securities and Exchange Commission and is merely a privately held run-for-profit corporation and not, as represented, a constitutional monarchy run by a government working in the best interests of the people who inhabit the landmass commonly known as Australia. 22. Principal makes oath that Watts McRae at no time provided written documentation nor made verbal comment to the effect that the Commonwealth of Australia Family Court is therefore merely a subsidiary of a private run-for-profit company that is not beholden to the will of nor working in representation of the people who inhabit the landmass commonly known as Australia. 23. Principal makes oath that Watts McRae at no time provided written documentation nor made verbal comment to the effect that the Commonwealth of Australia Australian Federal Magistrates Court is therefore merely a subsidiary of a private run-for-profit company that is not beholden to the will of nor working in representation of the people who inhabit the landmass commonly known as Australia. 24. Principal makes oath that Watts McRae at no time provided written documentation nor made verbal comment to the effect that the Family Law Act was merely statutes and therefore only gained the force of law with consent. 25. Principal makes oath that Watts McRae at no time provided written documentation nor made verbal comment to the effect that Principal could simply withdraw consent to avail of the professional services of the privately held run-for-profit corporation known as the Commonwealth of Australia Family Court and the Commonwealth of Australia Australian Federal Magistrates Court. 26. Principal makes oath that he was led to believe by way of deceit by omission that participation was mandatory by way of the juristic person Peter Andrew Nolan having citizenship of the Commonwealth of Australia, i.e. I was lied to by omission. 27. Principal makes oath that on many occasions and in writing, Watts McRae representatives insisted that the Family Law Act represented laws and therefore committed the common law crime of fraud. Principal makes oath that in email correspondence, Watts McRae representatives insisted that they had no comprehension of Uniform Commercial Code, the code under which the Commonwealth of Australia operates, and that common law was overridden by statutes. 28. Principal makes oath that on many occasions and in writing, Watts McRae representatives insisted that they are experienced in law. Principal enters into oath the front page of the Watts McRae website, which reads as at 22nd of September 2009. And I quote, "At Watts McRae, our specialised family lawyers are leaders in their field with a wealth of practical knowledge and experience. We understand the importance of providing our clients not only with expert advice, but also guidance during what is often a difficult time in life. We are committed to helping resolve our clients' matters promptly, cost-effectively, and where possible, without litigation." 29. Principal makes oath that the use of the term, quote, "leaders in their field with a wealth of practical knowledge and experience," unquote, is clear representation that Watts McRae lawyers are well versed in law, not statutes, and that they present themselves as providing reliable advice and guidance to their clients. 30. Principal makes oath that the private run-for-profit company known as the Commonwealth of Australia Australian Federal Magistrates Court proceeded to sell the property known as 8 Schofield Parade, Pennant Hills, New South Wales 2120, despite clear conflict of interest, collusion, non-disclosure of terms and conditions of contracts, deception by omission, and other nefarious mechanisms. Said company then placed proceeds of the sale of the house into a controlled account. 31.
Principal makes oath that the private run-for-profit company, known as the Commonwealth of Australia Australian Federal Magistrates Court, has acted against the specific written desire of Principal in selling Principal's property, thereby violating Principal's property rights. Principal saith not as good as avow, my signature, on the 23rd day of the 9th month, the year of our Lord 2009, so 23rd of September 2009, near London, England. It was witnessed by 3 men, their signatures of which are hidden from the public, but 230909 was when this was signed and sent. Now I just have to make an apology. I've read page 8 before I've read page 7. This is page 7 with the notice of intent and proposed remedy. This section of this document provides a notice of intent and proposed remedy inviting a respondent to peacefully and without dispute cordially resolve the matter at hand, that being the distribution of funds from the proceeds of sale of the house known as 8 Schofield Parade, Pennant Hills, New South Wales 2120. That this process has remained in dispute and large sums of money have been transferred to the Australian Law Society and the Irish Law Society by the process of members of said societies advising Jennifer Marguerite Nolan to create conflict rather than to pursue a peaceful and equitable solution merely for the benefit of the Law Society members has been a disappointment, though an eye-opener. The deceitful and unlawful activities of the Law Society members has not gone unnoticed, as it does most other times. Even so, it is proposed that peaceful and equitable resolution be made. It is the wish of the Freeman Society to extend the hand of peace and amnesty, and I as an individual are extending that hand of peace and amnesty to respondent in the first instance. A separate lawful notice is being issued to Judicial Registrar Johnston to pay the bill for the order he/she placed against the Principal for the sale of the house known as 8 Schofield Parade, Pennant Hills, New South Wales 2120. This lawful notice is not only concerned with the approximately $290,000 in proceeds from the sale of the house, known as 8 Schofield Parade, Pennant Hills, New South Wales 2120. This money is being held by Watts McRae at the current point in time. Based on the fact that it is understood the respondent is the correct human being to correspond with, to resolve this matter, the Principal proposes the following intent and proposed remedy. Should respondent be so willing to have a peaceful and amicable solution, Principal desires to discharge to 1. Discharge all outstanding loans and debts which are well evidenced by receipts, bank statements or affidavits from the $290,000 proceeds. 2. Split the remaining money on a 50-50 basis between Principal and Jennifer Marguerite Nolan. Principal proposes and will agree that Watts McRae issue bank transfers to all joint creditors, to juristic persons Peter Andrew Nolan and Jennifer Marguerite Nolan, so as to not require cooperation from Jennifer Marguerite Nolan, since none has been forthcoming for a period of nearly 2 years now. Principal proposes and will agree to respondent negotiating the proposed solution, in writing, copying Principal with the solicitors of Jennifer Marguerite Nolan in an effort to persuade Jennifer Marguerite Nolan that this is the best possible outcome at this point in time. Should respondent not be willing to extend the hand of peace and cooperation to resolve this issue with the minimum of fuss, Principal proposes and insists that respondent provide proof of claim as follows. 1. Respondent to provide proof of claim that she has lawful, not legal, right to retain the possession of the $290,000 currently held on account with Watts McRae. Please note this is page 7 of 8. I will now reread page 8 of 8. Should the respondent be unable or unwilling to produce proof of claim for lawful right to retain possession of the $290,000, the following remedy is proposed. 1. Respondent to apply her signature to a court order to transfer all $290,000 in favour of Christopher John Nolan. Christopher John Nolan is a man known for his honour and integrity, and he will not favour Principal in distribution of proceeds. He can be relied on to distribute proceeds fairly and to the best interests of the children. Principal further advises respondent that principal will enter into discussion with the father of Jennifer Marguerite Nolan by the name of Bill Toll, email and telephone number provided, so as to ensure that Jennifer Marguerite Nolan, receives a portion of the proceeds of sale of the house known as 8 Schofield Parade, Pennant Hills 2120 that is fair and equitable. Principal suggests respondent communicate with Mr. Bill Toll, who has been known to principal for 32 years, to assure respondent that principal will act fairly and honourably in all dealings with Jennifer Marguerite Nolan. Should the respondent be unable or unwilling to make the proposed remedy within 20 days of date of this notice, the principal retains the right to obtain a default judgment from a notary public or to form a court de jure to present matters of fact to the court de jure to make a judgment as to any and all violations of the property rights of principal and any remedy for those violations. The principal retains the right to have the court de jure make decision as to whether respondent has lawful right to retain the proceeds from the sale of the house known as 8 Schofield Parade, Pennant Hills, New South Wales 2120, and as to the amount of money to be paid as remedy. Principal also retains the right to remedy should respondent take further unlawful action such as transfer proceeds in the favour of Jennifer Marguerite Nolan. Any such order will be met with a bill for 10 times the amount of order against the human being who issues the order. Principal advises respondent that non-response is considered dishonour under law and that principal reserves the right to generate default judgments by notary public or convene a court de jure to pursue remedy should respondent choose to go into dishonour. Signed by me, 23rd of the 9th 09. Page 8 of 8. Now, just as an aside to the jury, I will try and edit this video file to take out the first reading of page 8 of 8. Now, the attachment, Family Law Act 1975 in the Family Court of Australia at Parramatta between Jennifer Marguerite Nolan and Peter Andrew Nolan. Order, 16th of June 2008, prepared in the registry. And this was sent to Louise Henderson. Family Law Act 1975, June 16, 2008, before Judicial Registrar Johnston, with the seal of the Family Court of Australia, Parramatta Registry. Upon application made to the court, it is ordered. Okay, so this is an order which can be billed. 1. That by consent, this is a lie. I did not consent to this. Okay, the very first thing they tell is a lie on this document, that by consent, orders made in accordance with paragraph 1, 2, 3 and 5 of the terms of settlement filed in court today and placed with the court papers as set out below. Orders made in terms of paragraphs 1, 2, 3 and 6 of the wife's amended application filed 11th of June 2008 as set out below. That both parties must forthwith sign all documents and instruments and do all things necessary to cause the property situated at 8 Schofield Parade, Pennant Hills, being the whole of the land containing certificates of title folio identified 6/209-830, the property, be sold by private treaty as follows. Okay, it says by consent. This is false. A. At a price agreed between the parties. B. With Keith Soames Real Estate, Wahroonga as the agent. C. With Robert Nasser of Platinum Lawyers, Marylands as the lawyer acting on the conveyances. 2. In the event of any disagreement between the parties with respect to listing and or sale price, then the parties shall obtain from the agent with whom the property is at such time listed a realistic appraisal of the selling price of the property on the basis of an eager but not over-anxious vendor, and parties shall then list the property for sale up to 105% of that price and shall accept the first offer of purchase at a price of 95% thereof. This is what they call by consent, right? 3. Upon completion of the sale of the property, the parties must do all things and sign documents necessary so as to cause the net proceeds of sale to be distributed as follows and in the following priority. A. In payment of agents' commissions. B. In payment of legal and all other proper costs of sale. C. In discharge of the mortgage in favour of St George Bank secured over the property. D. In discharge of any land tax liability in respect of the property. E. The balance of funds to be deposited in a controlled monies account as agreed between the parties and failing agreement to the trust account held by Robert Nassar of Platinum Lawyers, pending agreement of the parties or Section 79 order as to the distribution of the funds. 6. If either party refuses or neglects to comply with any clause of this order in relation to the execution of any deed, instrument or document, then pursuant to Section 106A of the Act the Court appoints and authorises the Registrar for the Family Court of Australia, Parramatta Registry, thereof to execute such deed, instrument or document in the name of the party who so refuses or neglects or further appoints that registrar to do all acts and things necessary to give validity and operation to the deed, instrument or document. Just remember, the very first words in this order were by consent, and then they say, if you don't do what we tell you to do, we'll do it for you anyway. This is their definition of consent, right? They are criminal scumbags. 2. That costs of both parties in respect of the wife's amended application be reserved. 3. That the husband's application for costs in relation to stay application be reserved. 4. Noted it is agreed between the parties that the balance of funds referred to in paragraph 3C of the wife's amended application shall be held in a controlled monies account by the husband's solicitor in the joint names of the parties pending further order of the court, meaning the money will be placed with Watts McRae. 5. That the husband have leave to relist his response filed 16/6/2008 on 14 days' notice following exchange of contracts for the sales of properties. Who are they to give me leave? 2. That orders are made in accordance with paragraphs 4 and 5 of the wife's amended application in a case filed 11th of June 2008 as set out below. 4. That both parties must forthwith instruct the managing agent for the property to deposit all that income received from the property to St George account in parties' joint names, account number 130203172, and must maintain that instruction until settlement of the sale of the property. Must maintain that instruction? I thought this was by consent. 23rd of the 9th, 09. Stamp applied. 5. That pending the settlement of the date of the property, each party must pay as before when such statements fall due to the St George account in the parties' joint names, account number 130203172, half of all funds required to meet the minimum monthly payment from the mortgage in favour of St George Bank, being any shortfall between any net rental income received in respect of the property and the minimum monthly payment. 3. That substantive proceedings be listed for directors by a registrar in accordance with the date to be provided by Judicial Registrar Johnson's associate. It is noted 4. The matters of paragraph 4 of terms of settlement, again dated and signed by Judicial Registrar Johnson. Now, there was no proof of claim provided by Louise Henderson within the 20-day time period. So I sent another fax on the 23rd of the 10th, 2009. You can see it was 2 minutes and 30 seconds and it was 7 pages and the result was OK. And this was the fax number. And this is the fax header page. So you can see it was this date, 23rd of the 10th, 2009, inquiry with respect to lawful notice. So you can see this is what was sent. Okay, this is the receipt for the cover page. I will now read this fax into the public record and into evidence for this jury trial. Fax 2. The human being calling herself Louise Henderson, also acting as Federal Magistrate Louise Henderson at her address. Date 23rd of the 10th, 2009. Subject: inquiry with respect to lawful notice. Dear human being calling herself Louise Henderson, salutations. I send this letter in peace and desirous to communicate with you or authorised representatives of the private run-for-profit corporation known as the Federal Magistrates Court of Australia. I have obtained your contact details from this page. So that was the page. And I trust they are true and correct. I am sincerely not aware of any response that may have been sent from you to me. Should there have been any such communication, I do most sincerely apologise for any miscomprehension of what has occurred. If you have chosen not to respond to my prior lawful notice, as I most sincerely believe is the case, I have now created a follow-up lawful notice for your consideration. I will place it into the Royal Mail today here in London, and it should be with you in a week or so. However, there is currently a postal strike in the United Kingdom, and mail may be slightly delayed. In consideration of this, and to minimise the time taken to send documents back and forth, I am faxing you a copy of the next lawful notice I will place in the mail today. Once again, it is my hope that we can communicate and settle this outstanding matter of the $290,000 in proceeds from the unlawful sale of the property known as 8 Schofield Parade, Pennant Hills, New South Wales 2120. Best regards, signed by me, page 1 of 1. And this is the lawful notice that was sent. Lawful notice to respondent, the human being calling herself Louise Henderson, also acting as Federal Magistrate Louise Henderson, 23rd of October 2009. 23rd of the 10th, 2009, page 1 of 6. Lawful notice to respondent, the human being calling herself Louise Henderson, also acting as Federal Magistrate Louise Henderson, with her address. Let right be done, though the heavens should fall. Notice to agent is notice to principal. Notice to principal is notice to agent. Notice to agent is notice to principal. I, commonly addressed by the calling of Peter Andrew Nolan, hereinafter the principal, in my correct public capacities beneficiary to the original jurisdiction, being of majority in age, competent to testify, a self-realised and free sentient man, my yes be yes, my no be no, do state that the truth and facts herein are of first-hand personal knowledge, true, correct, complete, not just true and correct, certain and not misleading, so help me God. This notice is addressed to the human being calling herself Louise Henderson, also acting as a Federal Magistrate Louise Henderson, hereinafter known as Respondent. Affidavit with respect to unlawful theft and sale of 8 Schofield Parade, Pennant Hills, between Jennifer Marguerite Nolan and Peter Andrew Nolan. Principal is of legal age and competent to testify. Principal has first-hand knowledge of the facts stated herein. 3. Principal makes oath that he issued a lawful notice to respondent dated 23rd of September 2009 entitled Affidavit with respect to unlawful theft and sale of 8 Schofield Parade, Pennant Hills, between Jennifer Marguerite Nolan and Peter Andrew Nolan, copy supplied. So this was also sent again to Louise Henderson. 4. Principal makes oath that the Royal Mail receipt number was RI 7747494889GB. Principal makes oath that he is not in receipt of this lawful notice by return mail and therefore sincerely believes that the lawful notice was duly presented to the respondent. 6. Principal makes oath that he has also sent a fax to the listed fax number of the respondent in a further effort to offer the hand of peace in discussing and negotiating an amicable resolution to the issues at hand. The fax number used was 61298935600. A copy of the transmission receipt can be presented as evidence should the respondent wish. 7. Principal makes oath that he does sincerely believe that respondent is now in dishonour, lawfully speaking. 8. Principal makes oath that he is not in possession of any documentation that would indicate that respondent has attempted to respond to the lawful notice presented. 9. Principal makes oath that principal has now completed a UCC1 financing statement. wherein principal has been legally defined to be the primary creditor and secured party for all property of the juristic person known as Mr. Peter Andrew Nolan, incorporated on January 11th, 1964. 10. Principal makes oath that he does sincerely believe that he now has the highest claim to all property of the juristic person known as Mr. Peter Andrew Nolan, incorporated on January 11th, 1964. 11. Principal makes oath that he is not in possession of any documentation signed under oath, penalty of perjury, and full commercial liability that any other party has higher claim to the property of the juristic person known as Mr. Peter Andrew Nolan, incorporated on January 11th, 1964. Further, principal saith not as good as aval, signed by me, the 23rd day, it was the 10th month, that's a mistake, 23rd day of the 10th month, year of our Lord, 2009, 23rd of October, 2009, near London, England. I had it witnessed by 3 people, 23rd of the 10th, 09. So this is a notarial notice of non-response and default judgment. Notice of intent and proposed remedy. This section of this document provides a notice of intent and proposed remedy, inviting respondent to peacefully and without dispute quarterly resolve the matter at hand, that being the distribution of funds from the proceeds of the sale of the house known as 8 Schofield Parade, Pennant Hills, 2120. The respondent has chosen not to respond and has therefore gone into dishonour, lawfully speaking. The respondent has refused the proposed remedy from the prior notice, that being to transfer the property of juristic person Mr. Peter Andrew Nolan to the bank account of Mr. Christopher John Nolan, such that this matter of distribution of proceeds of the property known as 8 Schofield Parade, Pennant Hills, New South Wales 2120, may be fairly and justly distributed to its rightful owners. In doing so, respondent has made claim that respondent has a higher claim to the proceeds of the property known as 8 Schofield Parade, Pennant Hills, New South Wales 2120. Principal hereby makes a second and final demand for proof of claim. 1. Respondent to provide proof of claim that she has lawful, not legal right to retain possession of the $290,000 currently held on account with Watts McRae. 2. Respondent to provide proof of claim that this claim is a higher claim than the primary creditor and secured party claim of principal. Proof of claim must be provided as an affidavit signed under penalty of perjury and full commercial liability. Should this proof of claim not be forthcoming, principal reserves the right to have respondent charged with the theft of property under common law and to present the facts of the matter to a court de jure for consideration as to remedy for principal and penalty for respondent. Should the respondent be unable or unwilling to produce proof of claim for lawful right to retain possession of the 290,000 Australian dollars, the following remedy is proposed to be executed immediately on receipt of this notice. 1. Respondent to apply her signature to a court order to transfer all Australian $290,000 in favour of Christopher John Nolan. Christopher John Nolan is a man known for his honour and integrity, and he will not favour principal in distribution of proceeds. He can be relied on to distribute proceeds fairly and to the best interests of the children. Bank details will be provided as needed. Principal proposes to 1. Discharge all outstanding loans and debts of the juristic person, Mr. Peter Andrew Nolan and Mrs. Jennifer Marguerite Nolan, which are well evidenced by receipts, bank statements or affidavits from the $290,000 balance. 2. Split the remaining money on a 50-50 basis between principal and Jennifer Marguerite Nolan, or by a percentage acceptable by affidavit by juristic person Mr. William Bill Toll. Principal further advises respondent that principal will enter into discussion with the father of Jennifer Marguerite Nolan by the name of Bill Toll, email and phone number supplied, so as to ensure that Jennifer Marguerite Nolan receives a proper portion of the proceeds from the sale of the house known as 8 Schofield Parade, Pennant Hills, New South Wales 2120, that is fair and equitable. Principal suggests respondent communicate with Mr. Bill Toll, who has been known to principal for 32 years, to ensure respondent that principal will act fairly and honourably in all dealings with Jennifer Marguerite Nolan. Should the respondent be unable or unwilling to make the proposed remedy within 20 days of this notice, the principal retains the right to issue a default judgment, there being no notary public readily available and willing to issue such default judgment, or to form a court de jure and present matters of fact to the court de jure to make judgment as to any and all violations of the property rights of principal and any remedy for those violations. The principal retains the right to have the court de jure make decision as to whether the respondent has lawful right to retain the proceeds from the sale of the house known as 8 Schofield Parade, Pennant Hills, New South Wales 2120, and as to the amount of money to be paid as remedy. Principal also retains the right to remedy should respondent take further unlawful action, such as transfer proceeds to the favour of juristic persons Mrs. Jennifer Marguerite Nolan. Any such order will be met with a bill for 10 times the amount of the order against the human being who issues the order. Principal advises respondent that non-response is considered dishonour under law and that principal reserves the right to issue a default judgment, there being no notary public readily available and willing to issue such default judgment, or to convene a court de jure to pursue remedy should respondent go into dishonour. Yours sincerely, signed by me, 23rd of the 10th, 2009. And as you can see, it was sent by fax. The next piece to be read into evidence and for this court and for the public record is a letter I sent. It was sent on the 22nd of the 10th. It was 11 pages sent. The result was okay. And this was for the 21st of the 10th, 2009. Inquiry with respect to lawful notice. So this was the sending of the affidavit that I just read into evidence. And this is what was sent. Fax to Louise Henderson, 21st of the 10th, 2009. Subject, inquiry with respect to lawful notice. Dear human being calling herself Louise Henderson, salutations. I send this letter in peace and desirous to communicate with you or another human being who is the authorised representative of the run-for-profit private corporation known as the Australian Federal Magistrates Court. I have obtained your contact details from this page, and this is from the fmc.gov.au site, and I trust they are true and correct. Please allow me to make this clear. This fax is not a lawful notice. It is a courtesy extended you by the hand of peace so that we may correct an injustice peacefully and appropriately. You have, of recent times, been involved in a family law dispute brought by my former wife, known as Mrs. Jennifer Marguerite Nolan, against my juristic person, known as Mr. Peter Andrew Nolan, incorporated on the 11th of the 1st, 1964, by way of a birth certificate. You may wish to contact Mr. Justin Dowd at Watts McRae or Miss Amy Zong at Sarah Bevan Family Law, should you wish to refresh your memory of your involvement. Please understand, I am now very aware of the differences between statutes and law. I am now very aware that the proceeds of my labour, my property, have been stolen from me on the basis of deceit, and therefore I am lawfully entitled to remedy. It has taken about 500 hours of study to really get to know what it is the courts are up to, but please rest assured, I completely understand the situation now. Please understand, I sent you a lawful notice on the 23rd of September, a copy of which is included in this fax. I have no known response to this lawful notice, and it has not been returned to me, so I believe it was delivered to you. This means you are now in dishonour, lawfully speaking. After much diligence and hard work, it has come to pass that I have discovered that the private run-for-profit corporation, known as the Federal Magistrates Court of Australia, is just that, a private company. As a private company, it held no jurisdiction over my legal entity, over my fictional legal strawman, Mr. Peter Andrew Nolan. The supposed jurisdiction over my financial legal strawman was only achieved by deceit, which is unlawful. It is my comprehension that the contract I signed with Watts McRae did not fully disclose all terms and conditions and did not disclose a conflict of interest and is therefore null and void ab initio, meaning from the beginning. This is unfortunate as Judicial Register Johnson issued an unlawful order for the sale of my property, thereby bringing upon himself liability for remedy. Bad luck, Judicial Registrar Johnson. He should have done his homework to make sure the order was lawful. However, Judicial Registrar Johnson and his problems are nothing to do with you. My comprehension of the current situation is that there is some form of hearing that is scheduled to take place in Sydney on the 26th and 27th of November with an authorised representative of the private run-for-profit corporation known as the Federal Magistrates Court of Australia. It is my comprehension that there is some unjustified expectation that I have some form of obligation to attend this hearing and I have some obligations for providing information for this hearing. Miss Amy Zong of Sarah Bevan has sent me some letters which contain the absurd assumption that I have some form of obligation to obey, quote, court rules, unquote. Since there is no contract between the private run-for-profit corporation known as the Federal Magistrates Court of Australia and myself, there is no obligation on me to attend. However, I am fearful that the private run-for-profit corporation known as the Federal Magistrates Court of Australia will attempt on that day to pass proceeds of my labour stolen by deceit to my former wife known as Mrs. Jennifer Marguerite Nolan. This is something that I wish to stop from happening as it only makes my remedy more difficult. Should no representative of the private run-for-profit corporation, known as the Australian Federal Magistrates Court of Australia, be willing to engage in conversation with me, I shall travel to Australia and attend this business meeting in my lawful and legal capacity as the primary creditor and secured party of the corporation, Mr. Peter Andrew Nolan. To ensure that further unlawful acts do not take place, any such hearing will be stopped in its tracks because I will insist that the court be put into common law jurisdiction, and you and I both know I have the right to do that as a sovereign. So to go ahead with this hearing will only be a waste of time and effort on everyone's part. Should I be forced to do this, I shall bill you personally for my inconvenience. I do not come cheap. As I said, this is not a lawful notice. It is merely a friendly and peaceful letter to let you know that you may well be about to incur a very large liability. I'm pretty sure you do not want such a large liability. I can assure you I will bill you more than you will earn in your lifetime. I want to also make sure you well understand that should you or any of your colleagues issue an order with respect to the juristic person, Mr. Peter Andrew Nolan, I will bill for that order for more than the person will earn in a lifetime and collect according to the bills of exchange that I am thoroughly familiar with. So you might want to let your colleagues know that I am very well aware I can bill for any order issued. That might slow them down a bit if they are desirous of issuing orders against the juristic person, Mr. Peter Andrew Nolan. After all, the juristic person, Mr. Peter Andrew Nolan, has a debt to me via a security agreement in the order of 10 million troy ounces of gold. If any magistrate issues an order with respect to juristic person, Mr. Peter Andrew Nolan, I hope to collect some of that gold. I wish to make it clear that I have filed my UCC1 financing statement and Mr. Peter Andrew Nolan has signed over all assets to Peter Andrew of the Nolan family and named me as primary creditor. You and I both know that primary creditor has the first lawful and legal right to all assets of a corporation. The private run-for-profit corporation known as the Federal Magistrates Court of Australia has no legal claim to the proceeds of my labour. I can prove this in a de jure court. I also wish you to know that I have today written to the man commonly called Robert McClelland, acting as the Honourable Robert McClelland, Attorney General, to lawfully notice him of your dishonour in responding to me and holding him personally accountable under law to ensure that his employees meet their legal and lawful obligations with respect to communications. I do not wish to be placed in the position that I am forced to travel from London to Sydney merely to communicate with you. That is what paper and faxes are for. However, if you choose non-response and remain in dishonour, I will travel to Sydney and I will bill you more than you can ever repay. I suggest you enter into an exchange of lawful notices, such that we can sort out the matter at hand. It may be that I can regain my property by notices to Mr. Justin Dowd, but that might take a while. In the first instance, I wish to make sure this hearing does not happen and that no further unlawful acts will be attempted by employees of the private run-for-profit corporation known as the Federal Magistrates Court of Australia. All unlawful acts committed will be remedied under common law, the law of the land. Yes, I am very familiar with Admiralty law and Uniform Commercial Code. Please do not insult me and demean yourself by arguing you don't know about these things. In my notice to you, I included a notice of methods of communication that would be acceptable to me. I suggest that you, or an authorised representative of your private company, start to communicate with me. Yes, that is a suggestion. I cannot compel you to act, but it would be nice and civilised if we started talking. One more thing, Louise Henderson, just in case you are wondering. Yes, we do know about the current program of genocide against the Australian people. We do know about the role of the legal fraternity play in that, and we are getting to that. Signed by me, Peter Andrew Nolan, and as I said, this was the 21st of the 10th, 2010. And attached to this, I included this affidavit with proceeds of sale to the house that I had sent previously. Okay, that was the 11 pages. Next, there is a fax sent on the 13th of the 11th, 2009 at 1:54, sent to this fax number. It was 10 pages, 4 minutes 15 in duration. You can see that it was the 13th of the 11th, 2009, this letter. Now I will read this fax into the public record and into evidence for this trial. Again, to Louise Henderson, David Dunkley and Amanda Morris to this fax number. Fax is 10 pages in total. 13th of the 11th, 2009. Subject, inquiry with respect to lawful notice and follow-up. To all the human beings who call themselves Amanda Morris, Louise Henderson and David Dunkley. Salutations. Firstly, I wish to address a point of law, common law. I am in receipt of a letter mailed to the corporate fiction Mr. Peter Andrew Nolan, Incorporated, 11th of the 1st, 1964, which he mailed on the 22nd of the 10th, 2009. It has a reference number on it, PAC 6601-2007. I can confirm that I have received this letter, noting that you are proposing some sort of business meeting you have called a, quote, final hearing, unquote, at the place of business of a human being calling himself David Dunkley. Since you have invited me to a meeting, please find attached my fee schedule for attending any such meeting. The fee schedule for my presence at this meeting, which you have invited me, is 10 troy ounces of 99.99% pure gold per hour or portion thereof. Failure to rebut this fee schedule in a lawful affidavit prior to Wednesday the 17th of November will result in a default judgment and acquiescence by default. Since I will be required to travel from London to Sydney to attend the meeting to which you have invited me, I shall add the amount of 500 troy ounces of 99.99% pure gold as compensation for the travel time that will be required of me to attend the meeting to which you have invited me. The bill for this travel time is attached and will be payable prior to any proceedings of the meeting beginning. The bill is to the human being calling himself David Dunkley, as he is named as the person who has requested the meeting by Amanda Morris. As yet, no authorised representative of the run-for-profit company calling itself the Australian Federal Magistrates Court has contacted me to describe the purpose or process of this proposed business meeting. I am sincerely of the belief that no effort to contact me has been made. Further, no authorised representative of the private run-for-profit company calling itself the Australian Federal Magistrates Court has been willing to respond to my lawful notices and has in no way established any contract or with or jurisdiction over any of my business dealings to the best of my knowledge. This means the human being calling herself Louise Henderson is in lawful dishonour of my lawful notices. It seems to me that the representatives of the private run-for-profit company calling itself the Australian Federal Magistrates Court are just as tardy in their prosecution of their business as they are their partners in crime, the lawyers. It is interesting to see how quiet you people are when you are challenged. All that education, all those fancy titles, all that government money you get, and yet you cannot respond to the simplest of lawful notices? My, you are starting to show how thin the veneer of justice is in the land known as Australia. These letters will make fascinating reading to the various men on the men's rights sites around Australia when they are published. Given that I am sincerely not aware that this meeting has been cancelled by the specified time frame, that I presume the purpose of the meeting is for your corporation to attempt to further steal the proceeds of my labour and my rightful property. I have purchased travel to come to this meeting to defend my interests against your criminal cartel. I am none best pleased at needing to come to Sydney to defend my interests against your criminal cartel. My expectation is to bill approximately 660 troy ounces of 99.99% pure gold to the human being who turns up on the day. I shall insist on immediate payment of the 500 troy ounces of 99.99% pure gold prior to proceedings beginning. Whichever human being turns up on the day will be required to bring this gold with him to pay my fee schedule. Further attempts to proceed with the meeting without payment will incur further fee of 1,000 troy ounces of 99.99% pure gold for lawful dishonour of a lawful fee schedule and presented bill. The human being who turns up will be required to sign an affidavit personally guaranteeing payment of this 1,000 troy ounces of 99.99% pure gold, as well as all other lawfully presented bills, prior to the continuation of any further discussions. Every further attempt to continue this meeting without signing the affidavit guaranteeing payment will be met with another lawfully presented bill for 1,000 troy ounces of 99.99% pure gold for each and every attempt to compel me to participate in a business meeting for which you do not have my written and sworn consent. I have at no time consented to this meeting. No details of the purpose of law or lawful nature have been forthcoming. The only reason I am attending is I believe your criminal cartel is going to attempt to further rob me, and I am defending my interests against your criminal cartel and your refusal to respond to lawful notices presented. Any attempt to characterise my attendance as consent is hereby denied. This letter may be presented in evidence to a de jure court to ensure that jury well understands that I at no time gave consent to this meeting. Amanda Morris, Louise Henderson and David Dunkley, let me be really clear about this. Whoever the human being is who turns up as the authorised representative of the private run-for-profit company calling itself the Australian Federal Magistrates Court had better be prepared to have liens and writ of execution placed against them for all their worldly possessions and everything they will ever earn in their lifetime should they attempt to compel me to performance without my sworn consent. As I said, I am none best pleased with events to date. I fully intend to ensure that those who have committed crimes and stolen from me will be brought to justice. I fully intend that further efforts to steal from me will be met with the full force of law of the land, the common law, to which each of you are subject. I fully intend to ensure your crimes are published far and wide. Best regards, Peter Andrew Nolan. And so that was sent on the 22nd of October 2009. There was a bill attached to it, bill to David Dunkley, order, travel to Australia from London for a meeting requested by Amanda Morris, invitation attached. The bill for the fulfilment of this order is 500 troy ounces of 99.99% pure gold, signed by me on that date. So bill for services ordered. Method of payment, David Dunkley to make payment of this bill in troy ounces of gold only. Terms, Peter Andrew of the Nolan family insists that this bill be paid prior to any proceedings of any meeting that has been requested by the human being known as Amanda Morris on behalf of the human being known as David Dunkley. So this bill means that David Dunkley had to bring his 500 ounces of gold with him to start this meeting, and he didn't do that. So, non-payment. Peter Andrew of the Nolan family retains the common law right to place a lien on the business of David Dunkley, as well as the right to form a court de jure to hear facts of the matter and to make judgment should David Dunkley not pay this lawful and due bill. Closing statement. Peter Andrew of the Nolan family wishes to thank David Dunkley for issuing this generous order and thanks David Dunkley for doing business with him and affording the opportunity to provide this bill for valuable services ordered. Peter Andrew Nolan wishes that we may do business again in the future. And here is the letter from the Federal Magistrates Court of Australia to Mr. Peter Andrew Nolan to Sarah Bevan. Dear Sir Madam, read Nolan versus Nolan, PAC 6601-207. I refer to the above matter which is listed for final hearing on 26 and 27 November 2009 10 a.m. Please be advised that this matter is now listed before Federal Magistrate Dunkley on those dates. Signed by Amanda Morris, Acting Associate to Federal Magistrate Henderson. So this was the invitation to come to a business meeting. I sent this fee schedule, and I will now read this fee schedule into the public record and into evidence for this trial. To whomsoever this may concern, notice of fee schedule. Let right be done that the heavens should fall. Notice to principal is notice to agent. Notice to agent is notice to principal. I, commonly addressed by the calling of Peter Andrew Nolan, hereinafter the principal, in my correct public capacity as beneficiary to the original jurisdiction, being of majority in age, competent to testify, a self-realized and free sentient man, my yes be yes, my no be no, do notice to whomsoever this notice is handed the following, so help me God. I claim my Creator has gifted me with a mind and the ability to speak and hear, and therefore He intends that I have the right of freedom of speech and freedom of thought and freedom of expression and freedom to hear other of His creations with no restrictions and no limitations apart from honouring He who created me. Furthermore, I claim my Creator has gifted me with 2 strong legs and a mind that can navigate, and therefore He intends that I have the right to freedom of travel across that portion of His creation known as the planet Earth, with no restriction and no limitations apart from honouring He who created me. Furthermore, I claim my Creator has gifted me with consciousness, life, 2 strong arms, and a mind that can use these arms with power and precision, and therefore He intends that I have the right to defend from harm or aggression myself and those He places in my care, with no restriction and no limitations apart from honouring He who created me. Furthermore, I claim that I may not be compelled to perform under any contract or commercial agreement that I did not enter into knowingly, voluntarily and intentionally, without full disclosure and fixed terms and conditions atop my signature, knowingly and consciously made by my hand. Furthermore, I claim that I do not accept the liability of the compelled benefit of any unrevealed contract or commercial agreement which are my rights pursuant to common law. Furthermore, I claim that any and all request to interact with me by any other human being requires my express consent. This consent may be expressed verbally or in writing by my notice of methods of communication. Once I have denied consent and communication, my fee schedule, either verbally or in writing, then the fee schedule for communicating with me against my express denied consent is 1 troy ounce of 99.9% pure gold per hour or portion thereof. Furthermore, I claim my fee schedule for presenting myself to any place of business describing itself as a court of law or similar, examples being family court or federal magistrates court, which is really just a privately held run-for-profit company, is 10 troy ounces of 99.99% pure gold per hour or portion thereof. Furthermore, I claim this fee schedule for wait time. I claim any such said court must provide an invitation to their place of business with a time, location, duration of request presentation with attached signed affidavit under penalty of perjury and full commercial liability that my fee schedule will be paid. Furthermore, I claim my fee schedule for any transgression by peace officers, government principals or agents or justice system participants is 1 troy ounce of 99.99% pure gold per hour, a portion thereof, if being questioned, interrogated, or in any way detained, harassed, or otherwise regulated, and 500 troy ounces of 99.99% pure gold per hour, or portion thereof, if I am handcuffed, transported, incarcerated, or subject to any adjudication process without my express, written, and notarized consent. Furthermore, I claim my fee schedule of 1,000 troy ounces of 99.99% pure gold for any and all unauthorized use of the fictitious corporate name Peter Andrew Nolan, or my calling Peter Andrew of the Nolan family, and all its derivations, each and every time it is used without my permission, which can only be given in red ink, signed by my hand only. Furthermore, I claim that all combinations of the fictitious corporate name Peter Andrew Nolan, or my calling Peter Andrew of the Nolan family, and all its derivatives are subject to a common law copyright agreement with the fee schedule as stated above, and such copyright is valid for the use of the fictitious corporate name Peter Andrew Nolan, or my calling Peter Andrew of the Nolan family, and all its derivatives for that portion of the kingdom of God commonly known as planet Earth. Furthermore, I claim the right to use a notary public or self-generated default judgment and writ of execution to secure payment of aforementioned fee schedule against any transgressors who by their actions or omissions harm me or my interests directly or by proxy in any way. Furthermore, I claim the right to convene a proper court de jure in order to address any potential criminal actions of any human being, especially peace officers, government principals or agents, or justice system participants who having been served notice of this claim, fail to dispute or discuss or make lawful counterclaim, and then interfere by act or omission with the lawful exercise of properly claimed and established rights and freedoms. Furthermore, I claim the law of agent and principal applies, and that service upon one is service upon the other. Furthermore, I claim the right to deal with any counterclaims or disputes publicly and in an open forum, using discussion and negotiation to capture as electronic video and sound said discussion and negotiation for whatever lawful purpose as I see fit. Affected parties wishing to dispute the claims made herein or make their own counterclaims must respond within 20 days of service of notice of this action. Responses must be under oath or attestation in the form of an affidavit upon full commercial liability, penalty of perjury, and sent according to the notice of methods of communication or by registered mail to the address below no later than 20 days from today's date, 13/11/2009. Failure to register a dispute against the claims made herein will result in an automatic default judgment and permanent irrevocable estoppel by acquiescence, barring the bringing of charges under any statute or act against Freeman Peter Andrew Nolan, and I provided my address. So, signed and autographed by me on the 13th day, the 11th month, the year of our Lord 2009, so 13th of November 2009, near Karlsruhe. Okay, I had it witnessed by 3 men, 13th of the 11th, 2009. Their signatures are hidden from the public. This concludes the reading into the public record and the reading into evidence for this court of the package of documentation which was sent to Louise Henderson and David Dunkley prior to me arriving in Australia in late November 2009. The jury and the public can clearly see that every effort was made to communicate with Louise Henderson and David Dunkley and Amanda Morris. That these servants of mine, people who took money from the public purse to do a job that they claimed they were doing, to continually refuse to answer lawful notices and go into lawful dishonour, demonstrates to the jury beyond any doubt that these people are criminal scumbags. That's the best way to refer to them. Okay, so this is the evidence that is read into the court record and read into the public record to demonstrate that I made every attempt to communicate with Louise Henderson and David Dunkley, and properly so. Thank you very much for listening.